Hi, everyone. Welcome to episode 209 of the Immigration Lawyers Podcast. I'm really excited about this one because it's pushing a trend I've been wanting to do for a long time, but I found excellent people to execute and team members to do this. In association with the Immigration Lawyers Toolbox magazine and the contributors, we're also bringing them on to add different video and audio content, which you'll be catching. And one I hope and I look forward to being a regular is Brian Green. Brian Green has a federal immigration litigation practice, one of the best out there, and he's doing real creative stuff. And he's so kind enough to contribute a lot of content to the Immigration Lawyers Toolbox. In addition, in this case, to hosting a show, interviewing Adam Rosen. Adam Rosen had a wonderful litigation case in employment base for AC21 and the ridiculous consequence of how the law has been interpreted, which he fought against successfully, that the beneficiaries on these kind of cases do not have an interest, so they don't get documents, they can't challenge it in court, and he pushed back on that. Adam Rosen from the Murty Law Group. So I really want you all to listen to this, learn about it, to help, galvanize the masses to say, hey, we got to push back some of these regulations. The way they're interpreted or executed are just ridiculous. I mean, it's not fair. And I think if anyone sees it in a normal light, will agree with that. So I'm looking forward to having that. Now, the views represented by the attorneys in this interview are their own. This is not intended for individual legal guidance. Definitely do your own research and hire your own attorney. But I really enjoy having these different perspectives, and I really respect and appreciate them for coming on the show to do this. So without further ado, let's check it out.
Welcome. My name is Brian Green. I'm an attorney in Colorado, and I'm very, very happy to have my former law school colleague and former practice and law colleague, Adam Rosen. We both attended Case Western Reserve University School of Law in Cleveland for 2 years at the same time, and we spent a bit more than 8 years working together in beautiful Baltimore, working at a very prominent boutique law firm called the Murthy Law Firm. Adam has been called encyclopedic in his knowledge of immigration law and is quite the litigator. And he is ready to share with us a very interesting, positive summary judgment win for the immigration bar. So I'm going to let Adam talk about his case. And if you could, Adam, in maybe 2 or 3 minutes, give us an overview of the case, kind of with an eye toward people that are lawyers that aren't full-time litigators.
Sure. So if you're an employment-based immigration lawyer, you'll have a better understanding of the nuances of this. As much as I litigate, that's most of what I do. So in the green card process, this involved an I-140 petition and the 45 application. It was filed in the I-140 was filed in the EB1C category. And so the 45 application was also filed concurrently with the I-140. After 180 days, and believe more than 180 days, the beneficiary left the company, and he got a new job. He filed the 45J using AC21 green card portability, and so then he moved again and filed a second 45J notifying immigration again about the change. In the interim, while this was happening, after the first 45J was filed with immigration, USCIS issued an RFE to his then former employer. He was never notified of anything, and from the record, it looks like nothing was ever sent by the petitioner, the former employer, to immigration, and USCIS denied the I-140 petition. Interestingly, in this particular situation, his 45 application remained pending, and it has remained pending to this day, which I think was lucky and doesn't always happen to everybody. He made some efforts to try and appeal the I-140 denial, but it got denied again and again because under the law, USCIS says you're not an affected party, and so we don't have to hear you or listen to you. So the judge here ruled that under AC21 portability, if USCIS decides to issue an RFE, then it has to go to the beneficiary as well as the employer.
And is that a change? Because I know in the decision, there was a lot of discussion about prior cases, both in DC and outside. And I think 1 or 2 of those cases were ones that you and I worked on at Murthy Law Firm. Was it Ravapalli or George versus Napolitano?
We worked on George versus Napolitano. We worked on Ravapalli. So Ravapalli was actually quite similar to this case because but the main difference, because it was involved a pending I-140 petition and a 45, the main differences between the facts in Khedkar versus USCIS and Ravaloppalli is the fact that in Ravaloppalli, the I-140 petition had not been approved. It was still pending, but the employer withdrew it, and USCIS denied the 45 application. And we sued over the 45 application as opposed to the I-140 petition. And in Khedkar, the I-140 had been denied by USCIS when there was no response to the RFE, and the 45 was still pending for at that time. And it helped some extent that the 45 was still pending at this point in time after all these years.
So these are all AC21 related litigation cases, right? That kind of came out with different outcomes.
Yes, these are all AC21 related litigation cases. And in fact, initially in the government's answer, they laid out they laid out venue as one of their defenses. However, in our motion for summary judgment, we addressed the venue piece and explained to the court that under the law, the district is appropriate, even though the plaintiff was not residing and the employer was certainly not residing in DC. Under the law, we argued that venue is appropriate in DC because the district as a whole was familiar with these legal issues. Because besides Ravaloppalli and George, there were, I think, 2 other cases that had in the past been litigated involving AC21 related issues. And so on that principle, we argued that venue was appropriate. The government did not pursue that argument in their motion or in their motion, their cross motion for summary judgment. So it worked out, yeah.
So the viewers and listeners can look at this case. I don't think we have a case citation yet. Can you give us the case title for the case where you won summary judgment?
Sure, it's Khedkar, which is Khedkar versus U.S. Citizenship and Immigration Services. So,
and which judge issued that decision?
That is Judge Contreras.
Okay, Rudolph Contreras, who was a former I guess he would be the chief of the civil division at the U.S. Attorney's Office before he became a judge, right?
Yes.
So, and anyone that needs those other cases, they're all cited in Judge Contreras's decision, correct?
I believe they all are cited there, and there's also some of the cases that there's the Montana case that involved a similar challenge, but that and another case that involved challenges to the revocation of the I-140 petition, and arguing that the beneficiary had an interest in those cases. So those are discussed and cited in the decision.
So anyone that's looking at this and has a similar issue or has an AC21 litigation issue, they need to go to Westlaw or Lexis. They need to get a copy of this decision when it's published, and they need to shepherdize it. All the cases will be there. From my perspective, I think the majority of the immigration bar is getting comfortable with filing lawsuits, and they file complaints and then negotiate. They might do service of process, but very few of us really have gotten to do hardcore summary judgment litigation. And then in this situation, you're not litigating facts as much as you are litigating policy, regulation, and statute. Can you talk about the interplay between the statute, the regulations, and how that was a challenge for you or how it was a weapon for you in summary judgment?
So it is definitely a challenge because it's both, in this case at least. It's a challenge because you are trying to make what to some extent is a novel argument that you're looking for relief that hasn't been previously granted. And as I'm sure many other immigration lawyers out there can attest to, trying to get a result like this with USCIS actually issuing the RFE and listening to the beneficiary's response has been so very challenging over the years. So it's looking for a way to pull together the statutory provisions, the regulations, and whatever policy to explain to the court that this is a reasonable result. And I think that part of what I got from this was explaining to the judge through the existing law, and ideally the statute, regulations, and policy, how this is a reasonable decision, how almost what the plaintiff is arguing is inevitable, how can you conclude otherwise, is really the best way to do this, because you're not asking for anything particularly novel. And I think that's part of what made a difference in this case to lead to the decision that Judge Contreras issued.
In my reading of it, and I read the case thoroughly yesterday, it seemed pretty obvious that Judge Contreras understood that USCIS had chosen not to issue regulations that were harmonized with the AC21 law, and they were relying on regulations that predated AC21 and led to a pretty ludicrous outcome, which is the AC21 porting worker having no ability to respond to an RFE or a notice of intent to deny.
Exactly, and parts of what we argued were based on the Federal Register notice, the preamble that issued the new regulation on AC21 and that came into effect in 2017. And part of the argument was actually pulling together the various regulations and the language that's currently there in 8 CFR 103 that talks about who's an affected party, and then in 8 CFR 102, when you're issuing an RFE, who do you issue an RFE to? And trying to highlight the conflicts and contradictions between these different sections, and the fact that you have, particularly one case that was particularly helpful was the BIA decision in matter of Al-Wazan that talks about where the BIA said, okay, if we have somebody in removal proceedings who has an approved I-140 petition, even though the 485 is normally outside, even though the I-140, is normally outside of the jurisdiction because only the 485 is in our jurisdiction, they said, you know what? Congress passed this law in order to help protect foreign national workers. And if we deny this, if we deny our willingness to adjudicate whether the job is same or similar, then that defeats the legislative purpose. And so I argue to the court, what USCIS is trying to do here, what they've tried to do here with the plaintiff, is say, no, you can't do this, which in some sense is the same thing as what the board said in Al-Wazan, that they were forced to, by the circumstances, to take on the jurisdiction of analyzing whether a job is the same or similar. And I think all of these factors together made a big difference in helping, one, the judge understand our position, but also see why, the regulations that are in effect now are outdated and need to be changed to make sense for what AC21, just from the plain language, was trying to accomplish.
I think your cat agrees as well.
Yes, he does. Yes, he does.
So it sounds like this was a tremendous amount of work. Can you give us a ballpark on how many hours you spent on the lawsuit and how many hours you spent working on the summary judgment phase?
Good question. I have it saved somewhere because I'm hoping one day I'll be able to file for each of these.
Ooh,
but,
right. And did you keep
the government has?
Did you keep contemporaneous?
I did keep records and counting as I was working on it. And there are probably some time that I was working and did not track it, and those are gone with the wind. But I'm hoping, the government has to decide if they want to appeal the case or not. They still have time running, and maybe they'll ask for waiving each of fees in exchange for not appealing. I don't know. Probably not. They'll make their decision on what they want to do.
I would not accept that offer. Bringing up settlement, has USCIS engaged in any settlement negotiations in this case before?
No, they have not. They have not.
So I mean, from my perspective, I wonder if the lawyer that got assigned the case on the DOJ side was like, well, they're not going to change or promulgate regulations right now, so I have to defend this case. And as lawyers, we don't choose our facts. We may emphasize different facts or try to hide facts, but we don't get to actually create them. And I felt a little sympathy for the DOJ lawyer that's looking at this saying, this is obviously wrong structurally. How do I win this case?
I mean, I think her pleadings, her motion and replies, they were definitely well written. I'd like to think that their case was weak, and she did, but I do think that she certainly is, she's there in that position because of how good she is at her job. And
sure.
So very, very pleasant to deal with. I mean, I've always had a good experience working with the assistant U.S. attorneys in the D.C. office. But I think that, I think part of the weakness of the government's case here in general, and on most AC21 issues, is the fact that AC21 was enacted in 2000 and the first regulations came into effect in 2017. And in the interim, you got some memos and so many different things happened that nobody ever took account for in issuing these regulations. And I'd like to think that this case will send a message to the agency that they do need to start making some changes. I don't expect any regulations anytime soon, but I do think that there is enough room between the language in the current regulations and the language in the statute that they can issue some kind of guidance saying that in these particular facts, this particular situation, issue the RFE. And I think that the decision in the matter of ESG case that the AO issued and the subsequent memo that USCIS issued, I think is a path for immigration to go down. And I'm hopeful that with the new director who previously was chief counsel and has worked on the other side, can appreciate the need to do this, and that there is a mechanism to do this short of regulations, because honestly, I mean, if it took 17 years to get the first set of regulations, I don't know that it would take less to get the second set.
And matter of ESG, that's Victor Sam Golf. That's the adopted decision from AAO.
Yes, for the question of the beneficiary pursuing a revocation of the I-140 petition. Again, they're I-140 approved, 45 pending for at least 180 days. And then USCIS begins revocation proceedings. So in that case, the argument that USCIS or the AAO accepted and then the USCIS issued in a memo was that if you've notified USCIS about your porting, and I believe they say the notification has to come pre-issuance of the notice of revocation, but they said that if we're notified about your porting and we're going to issue a notice of intent to revoke, then we will issue it to the beneficiary as well. And I did actually have a case where they issued the notice of intent to revoke to the beneficiary. They issued it also to the petitioner, and we responded to that. And it did reflect an examination of the issues consistent with the policy memos. So for the issue of ability to pay was looked at a little bit differently as well.
So to boil this all down, this is really a big fight over standing for workers in the green card system and whether or not they get to step into the shoes of the employer to defend their I-140 cases that they had ported, right?
Yeah, it really comes down to standing. That's the essential question here is whether or not the foreign national is an interested party and whether they have standing in the court and, as this court looked at, before the agency.
So, I mean, I think it's a fantastic decision. Judge Contreras he litigated these cases or supervised people litigating these cases for a number of years. DC is the hotbed of APA litigation and that regulatory fight that goes on. How can this case help other litigators in the immigration bar? Or if it's narrow, what did you take away from the case that you want to share with the immigration bar and people that may be faced with really complex litigation cases, especially business immigration cases? What, from your perspective, was your takeaway?
Read the regulations and the policy memos and the statutes really carefully. I mean, and even separately from the case law, I have to say that, there's a lot of case law that I pulled up and that I wove into the argument that I made. But I think that one of the things that struck me, and it was not early on in the case, but that struck me was that, and was a point that I made to the court, was that the policy memo from 2005 about the question of what does USCIS do regarding the pending I-140 petition when the 45 is for 180 days is actually incorporated a little bit indirectly, but it is incorporated into the AC21 regulation of 245.25. And it's not necessarily the most obvious thing, but it is there. And Judge Contreras does quote from that portion of the regulation. And so I think it's worthwhile, even in the more challenging cases, to take a step back and think about it differently. I mean, I had a couple of clients approach me about an H-1B case and pursuing litigation because they, in the master's cap issue, where they've been told by USCIS after all these years that, you've not been counted against the cap. And typically, I think we look at the H-1B petition as something that is just the petitioner's petition, and they're the only interested party. But if you think about it, they're in that particular situation, there's a clearly defined.
It's huge for them.
Yeah, I mean, they have a clearly defined interest that, in some sense, is even greater than the petitioners, because are they counted against the cap?
They can work for multiple employers,
Exactly,
right?
Exactly. So I think it's definitely worthwhile sort of turning around what you have, looking at it from different perspectives, and see how things combine together. I mean, you may be able to come up with something that nobody has ever thought of. And the fact that nobody has ever thought of the argument just means that nobody's ever thought of it. Doesn't mean that it's a bad argument, or, that not the right argument. So I think that's probably
so as our Indian clients. That was our biggest takeaway. So our Indian clients would always ask us a couple of times to make sure that they got the answer that or understood the answer that they had received. I'm hearing you say you need to print out, and I'm still, I hate to kill trees, but you print out all of the raw material, the statute, the regulations, the commentary, the Federal Register, the preamble. You print everything out, you get a highlighter, and you just read everything, you highlight everything, and you kind of let that marinate in your brain and try to figure out you try to whiteboard it with your colleagues, you try to sleep and next day look at it again, but you're trying to look at all the material and, like a chef, try to put the recipe together to put together an argument that may not be out there. I think as immigration lawyers, we're kind of trained to find cookie cutter. Someone did this before, I'm going to use the same thing. As litigators, we look to Westlaw and Lexis. We want to find a case somewhere in a different district or different circuit that kind of address it, but it may not be out there. We may have to cut from whole cloth. And if you have all of that material, if you're a master of all that material, you have a better chance of weaving it together in a way that benefits your client.
Yeah, I work better with things printed out. So even when I was writing the motion, I would print stuff out, I would circle stuff and highlight stuff, and I'd have 20 pages on the floor just spread out and trying to move things around. Everybody has their own style for working, but I do think the biggest takeaway from this case is, think as creatively as you possibly can. You might very well come up with an argument, even if you haven't been practicing for many years, you haven't litigated for very long, but you may very well be able to come up with an argument that makes sense. And the fact that somebody else has never tried that argument does not mean that it can't be successful. I think you're trying to make the situation sound reasonable and logical to the judge, and to explain to the judge, this is why it's the plain and most inevitable result that should be the result in this case.
Fantastic. So
I think that, yeah.
I know you have a lot of great colleagues at Murphy, and you get to round table and whiteboard with people. I'm a solo, so for me, my colleagues, my coworkers are the ALA members, the people that I bounce ideas off of. So if you have this situation or something similar, and you think you can't grasp it all, maybe talking to a mentor from the ALA, we now call it the High Impact Litigation Committee. I'm a member of that. Reaching out to Adam, I know you've helped a lot of lawyers in your career. There are other people that can help you get different perspectives. But if you're talking about 50, 60, 70 hours worth of work, you may actually want to try to co-counsel with someone and share the expense and the profit from it. But hopefully you frame that win and put it on the wall, maybe just the first page, I'll put a little autograph on it. But I'm happy to see you get this win. I was excited to get to receive it in my email. And hopefully we can do another interview in another 6 months or a year when you have another great policy setting decision for us.
I look forward to it, and thank you for all your years of mentorship. Brian's a great attorney, great litigator, and also a creative thinker. So thank you for your time as a colleague. Yeah. Go Case Western.
That's what we need. Yeah, go Case Western. Go Spartans. Thanks, everyone. We will hopefully talk to you again soon.